thank you everyone for joining us on our webinar today that's going to address tips for good service, looking at some strategies for successful, for safe and effective service of process. We appreciate you coming. We have over 100 people right now. We have many people register. There's obviously a lot of interest in this topic, and we hope that you'll walk away with some good practical advice on how to improve your systems, your jurisdiction's approach to service of process for civil protection order cases. We're bringing this program to you under the auspices of the National Council of Juvenile and Family Court Judges and our Civil Protection Order Guide project, which is a technical assistance project to help communities around the country think about how to best issue, enforce, serve, of course, orders, civil and criminal orders of protection, really. We work on both of those. And Stephanie she's already chatted in a link to some information on the project. We are available for technical assistance on all of these topics. Please reach out and we'd be happy to assist you on a one-on-one basis or your community in trying to do some good work in this area. And of course, we'd like to thank the Office on Violence Against Women at the U.S. Department of Justice. We are operating a cooperative agreement from that office. And so we thank them for their generous support, both financial support and also substantive support of the work we're doing under this project. What we talk about today will be the views and perspectives of the presenters only, and not the office. But we're very happy to share with you some great information from some practitioner experts that are joining us today. So I'm sure the vast majority of people who have joined us know that in order for civil protection orders to be enforceable, the respondent, the person against whom the order has been issued, needs to have actual notice of the order, of the existence of the order, of the terms of the order, and needs to learn that there's an opportunity to be heard before the final long-term order will be issued. Due process, of course, requires this. And typically, the notice requirement is met through service of process, which is the formal handling or kind of handing over of the paperwork, the order itself and any other paperwork to the respondent, usually by a designated law enforcement agency. But I know that many of you are familiar with and even implement some alternatives to this kind of formal service of process by law enforcement procedure. And, they can include things like substituted, or we sometimes call constructive service, which may be available in some of your jurisdictions under certain sets of circumstances. For instance, if there's evidence that a respondent is evading service and there have been multiple diligent attempts to serve the person, a jurisdiction may allow for serving another person at the residence. A person of suitable age and discretion is often the language used. It usually has to be another adult at the defendant's home or at their workplace. Some allow even the posting the paperwork on the door and a follow-up mailing of the copy to the last known address. And in some jurisdictions, there can be service or notice by publication in a newspaper. So, of course, in addition to those kind of long-standing alternative forms of service, we're also seeing the emergence of electronic, or sometimes we call e-service of civil protection orders. And this can usually entails emailing, sometimes texting, or even posting on social media the documents, sending them to the respondent's cell phone, or to their email address. And just for your information, if you're unaware of this, the 2022 VAWA reauthorization includes a grant program that's going to fund some pilot jurisdiction to develop and implement e-service programs for protection orders on a pilot basis, so we can all learn how they work. But we have the benefit here. One of our expert practitioners today from King County, Washington, has some pretty extensive experience with electronic service in her community, and she's going to share some of her lessons learned and suggestions for practice in this area. So that's the backdrop for what we're going to talk about today. We want to talk about, as I said, some specific concrete strategies to ensure that service of process is effective, that it's swift, that it's safe for everyone involved. We'll talk a little bit about firearms as part of that process as well. The reason we pulled folks together today is because we and other national technical assistance providers have been getting a lot of questions from jurisdictions where service is really posing a challenge. Some instances it's resource constraints or lack of personnel, Sometimes it's attitudinal or failure to kind of prioritize civil protection orders for service as part of the responsibility of a law enforcement agency. There's a whole list of barriers out there, and we wanted to start to help folks to start to overcome and address those barriers by learning from some folks who have had success in this field, who can tell you about what they're doing every day in this work. We would love for this session to be interactive to the extent possible. We have a big group, but we have chat open. Please do chat. We'll be monitoring the chat. We'll be responding to the chat as we can as we go through the session. I'll be moderating the conversation, and I'll be asking our expert practitioners to respond to some specific questions. We don't have slides today to share with you. It's going to be much more of a conversation. And I'm going to have the experts we have with us, they'll be introducing themselves as I ask the first question. So with that, let's get started with our conversation. And I'm going to start by turning to a couple of folks that we have from Lafourche County, down in one of our favorite states of Louisiana. We have Lieutenant Valerie Martinez Jordan and Sheriff Craig Weber. And I'd love you to go ahead and introduce yourselves. And also, in doing so, can you describe to us a little bit about how you approach service of process for civil protection orders and what you think contributes to the success you've had in serving those orders safely and effectively?
Well, good afternoon. My name is Craig Weber, and I have the honor of serving as the sheriff of Lafourche Parish in Thibodaux, Louisiana, down on the Gulf of Mexico. And I'm joined by my rock star, Lieutenant Valerie Martinez, who knows everything there is to know in the area of civil process, domestic violence, firearm prohibitions, all of those things. But for purposes of the question that you're asking, and as the CEO, as a sheriff, you have to prioritize. And you mentioned attitude and prioritize. You have to recognize that a civil protective order is a unique order of all the civil process. And you're correct. There is no due process of any kind without notice, whether you're suing someone for divorce or for a car wreck, or it's a civil notice of order protection. And when I say prioritize it, by its name, by its nature, there's the someone's in harm or potentially in harm. They wouldn't call it an order of protection or protective order or what have you if it were not designed to prevent actual or potential future harm to a victim or a petitioner. The flip side of that, though, is this order is also an order that carries very severe consequences to the respondent or the defendant. It's an order, unlike most civil orders, that criminalizes many normal day-to-day interactions, such as sending a text message, driving in front of someone's workplace, having communications even with third parties. So to not recognize the uniqueness and prioritize this type of order is a failure, in my opinion, on the agency, on the person responsible, and on the CEO. And that's important as a beginning standpoint, because then it leads you to the process of how do you get them served and how do you get them served in a timely fashion. And much of what needs to go on is you have to be able to work through and streamline the bureaucratic obstacles that exist and the timelines. You know, the conventional protective order gets issued when the petitioner goes to court, sometimes pro se, sometimes with an attorney, and interacts with a judge. And that judge issues an order, and the order goes to the clerk, and then the clerk has to have the order properly logged and tracked and then sent to the serving agency. So all within those various players in the system and the parameters of getting it from a signed order to service, you got to work through those log jams. And even if you get it to the serving agency, and I'll say the sheriff's office in Louisiana, because we are the agency primarily responsible for service process, within your own organization, you have to prioritize it. So I'm going to turn the rest of the time over to Lieutenant Martinez, who has worked very, very diligently with our clerk of court, with our judges, even with our district attorney. And actually in Lafourche Parish, because we're very proactive, many orders of protection begin with an advocate here at the sheriff's office working with the victim to get the order, to petition for the order in the first place. So we know firsthand when many of those orders are issued, because we're there in court when the judge issues them. But for those that we are not there in court, we have it worked out with our clerk of court and other members of the criminal justice system to get that order to us so we can prioritize it and get it served. So Valerie, you take it from A to Z.
So what happens is we have an advocate in our office. She is non-law enforcement. She assists and aids the petitioner at the forefront. We escort the petitioner to the court, assist them in filing. We have coordinated and recognized the importance, and our clerk of court submits to us electronically the orders upon issuance. So we receive them immediately. Once the judge signs them, they are sent to us electronically. We put them to our electronic database that is real time, that is in our officers' patrol units. And if not, and it needs to be served, we then take that order and we go out and we serve the defendant personally. So we have legislation that passed that allows for us to print the document from an electronic system if necessary to expedite the service.
And we bypass our normal service of process office. Those orders go strictly to our police social services, domestic violence unit, and they immediately seek to make service. And if they can't, at the end of that time that they've tried, they'll pass it on to the patrol division. And within the patrol division, it's a priority service. And because the order is electronically sent to us, every deputy has access to that order 24/7 from inside their patrol unit using their laptop. So there's no ambiguity whether the order exists, whether it has been signed or not. And then, of course, there are other occasions where the defendant is arrested and is incarcerated while the person is protecting or petitioning for protective order. In those cases, it's pretty simple and straightforward. We take the order strictly from the court, bring it to the jail, and serve it to the defendant while they're incarcerated.
Under your process, the first attempts at service are made by a specialized unit, group of officers, and if the shift ends and they're unable to serve, it then goes to patrol. But they themselves have service of these civil protection orders as a priority for them. Is that correct? Am I understanding that correctly?
That is absolutely correct. And in addition to that, we've secured grant funds that we have in off-duty detail where the officer's only role is the execution of those protective orders, not any other civil process, no other document, but those specific orders of protection.
Valerie, on average, what would you say is the time from issuance to service?
From issuance to service of an order could be anywhere from 15, 20 minutes to an hour to 2 hours.
For the majority of your orders?
Yes.
That's great. So we'll talk in a little bit about how you got to this point where you have such an efficient and effective process, but I'm going to turn next to our next panelist, Shelley Hunsinger de Enciso from King County and the prosecuting attorney's office there. Would you introduce yourself and talk to us a little bit about your what happens in your county and what you think contributes to the success there around service of process? And I know it's a little bit of a mixed bag in such a large, diverse county, so we'd love to hear a little bit about that.
Yeah, for sure. Hi, so my name is Shelley Hunsinger de Enciso, and I have been with the Prosecuting Attorney's Office Protection Order Advocacy Program for the last 5 years. We have a special program in our prosecutor's office. We just celebrated 35 years last Friday. And we have a team of advocates out of 2 different Superior Court locations who assist petitioners with every aspect of a civil protection order. Because of our capacity, we limit ourselves to civil protection orders between intimate partners in domestic violence cases. But we help with anything related to that, and that includes service. So here in King County, you know, the global pandemic, COVID, was a terrible thing. It gave us nationally many challenges. However, in King County, we did kind of have a silver lining in that the necessities of the pandemic showed us that we could use technology to create an infrastructure that works for survivors. So it was kind of that pandemic, kind of the catalyst, but then it was also coupled with kind of some current and anticipated budget constraints. And just plus the changing nature of the times and technology, you know, Washington State being kind of a tech hub, what with Microsoft and all of that, it let us know that we needed an overhaul. We needed a modernization of the protection order statutes, and included in that with service. Requiring personal service of all protection orders was something that we decided that we were going to re-envision. And for a while, we considered kind of easing the access to the existing alternatives that we had. So we had the alternatives of service by mail, postal mail, or service by publication, but those weren't really viable remedies. They were pretty antiquated. People don't really check the newspaper. Often people don't check their postal mail anymore, and they don't guarantee actual notice, and they're often really insufficient to enforce should there be a violation. So we saw that we had the tools and technologies kind of ready to address the gaps. And some of these proved to be more successful in achieving actual notice and promoted more fiscal and judicial economy. So prior to COVID, we had no way of obtaining a protection order virtually. People were told if they couldn't make it into the courthouse, they couldn't get an order. And that presents challenges for everyone because of transportation, childcare, taking time off work. We did not have e-service. And because personal service poses like a variety of challenges, we saw our courts becoming kind of this revolving door of continued hearings over and over again due to no service, spanning many months. They were crowding the dockets that were already busy. We had a negative impact on the courts, undermining judicial authority. We had a negative impact on the litigants, who oftentimes would kind of wash out of the process before ever giving an order just due to attrition. And then we didn't have any way to attend hearings except for in person either. And of course, we know that there are safety risks for petitioners in attending a hearing where the respondent is going to be, plus the additional challenges of the transportation, the childcare, the time off work, etc. So during the pandemic, we saw our courts close down, but we saw a greater need for protection orders than ever. So we had to institute some kind of emergency process for filing orders and attending hearings remotely because our courts were closed. And then we had law enforcement who weren't wanting to go out and serve in person these orders because of COVID. So COVID kind of gave us this opportunity to modernize the way people engage with the systems. And we really kind of leaned into the idea of using tech and letting us do things virtually. So things that for us were a pipe dream pre-COVID are now a reality for us. Governor Inslee signed a proclamation that authorized, among a few other things, electronic service of process. And that gave us an opportunity also to kind of pilot and evaluate what we were doing. I will let you know, King County, like you mentioned, is a very big jurisdiction. We have 39 different law enforcement agencies. Our county is urban, it is suburban, it is rural. And so it really is a mixed bag. All these 39 different jurisdictions have their own ways of doing things. But what we decided to do was a pilot with the Seattle Police Department during COVID. I will note that, when e-service was first authorized, there were still a lot of questions among law enforcement and even in the courts themselves about what that was going to look like and who was going to accept it, et cetera. So this pilot study actually ran between March 25th of 2020 and July 17th of 2020. So only about like 4 months. And in that time, the Seattle Police Department received 665 orders for service, and of those, 78 were served electronically. So we did a pilot study and we looked in depth at those 78 cases. And what we found was really amazing. We had 96% of the respondents who received electronic service confirmed receipts of the documents with the detective who emailed it to them, which was just unprecedented. Only less than 4% of those respondents did not formally respond back to law enforcement. But interestingly enough, all of the non-responders actually were present and participated in their next scheduled court hearing. What we found that of the respondents who were electronically served, 87% participated in the protection order process, leaving only 13% that did not. And that is a remarkable rate of participation compared to what we had prior to COVID. So historically in King County, the participation rate in Superior Court protection order cases averages about 50 to 55%. And so with e-service, we were seeing during this pilot a participation rate of 87%, which is just amazing. What we do think, however, is it's probably not all due to e-service, but it was likely also due to some expanded options for virtual appearance as well. We think that helped out. We had a few hiccups in the beginning. Some officers weren't sure when they were allowed to e-serve. We had a few hiccups where the court was requiring prior approval for that. Some officers were kind of taking it that the respondent had to agree to the e-service. So we had a few hiccups in the beginning, but based on those successes, as of July 1st of 2022, we passed a new law in Washington modernizing and updating our protection order statutes. It codified e-service into law now in our state, and also the ability for petitioners to file their orders remotely and to appear for hearings remotely, which is something that we also did not have prior to COVID. It was important when we wrote this into law that we not be too prescriptive and require the respondent to confirm receipt, because we know that, efforts to evade or evasion of service by respondents is definitely a thing. It's a threat to access to justice for survivors. And so it was important that we had a requirement that couldn't, be stalled by a respondent's refusal to agree. So now our statute says verification of receipt may be accomplished by one of several means: through a read receipt mechanism, a response, a sworn statement from the person who did the service, and or any follow-up communications. So we've got kind of a variety of things codified there. The benefits that we have seen, so we've been doing e-service now for 3 years. The benefits that we've seen, it's more cost effective and a productive use of law enforcement resources. Law enforcement is not having to run around and do all the service, which allows them to focus on high-risk service. We do have some high-risk cases that still require personal service in our state, which is if we're asking firearms to be removed at the time of service, if we're transferring child custody, if we're vacating the respondent from a shared dwelling, and also if the respondent is incarcerated because they probably won't have access to an email at that time, which kind of reduces that revolving door of these unsuccessful personal service attempts over and over. Officers don't have to keep going out. We've seen it's more cost effective and productive for the courts because we are having less people having to come back over and over again for lack of service. What we've seen and what we think maybe contributes to the high participation rate is that it appears to be less stigmatizing for respondents. They don't have a police officer showing up at their door where the neighbors can see, or showing up at their workplace. And it is potentially less threatening to them and potentially not escalating an already volatile situation. It seems to promote procedural fairness and access to justice for both parties. Because respondents are getting better notice, better actual notice. They're getting better notice of appearing at their hearing, and petitioners are seeing their cases move forward faster. And petitioners have a right to get to court. They shouldn't have to be dependent on the respondent's kind of evasion games in order to get an order. Because those repeated delays cause these huge attrition rates, and a lot of petitioners wash out. And so it promotes this procedural fairness for both parties. And during the pandemic, it really promoted public and officer safety by reducing unnecessary in-person contact. There are definitely some drawbacks. Implementation takes time. There's a learning curve. It was a very big change for us. There is a digital divide. Not everyone has access to the internet, but most people do have smartphones, and a lot of people can receive email on those. And so we also have the ability to serve by email, by text message, or by social media. And so most people have smartphones where they can access that kind of thing. We still are working on developing kind of some accepted and standardized best practices Some of our jurisdictions are much better at implementing this than others are. Some of them still appear to be kind of afraid of it. Our new statute does say that electronic service is to be prioritized in all cases except for those high-risk cases I mentioned. So we're still working on it, but overall, it's been working really well. And our takeaways from this process are that, coupled with the ability to be able to appear at hearings remotely, has created a more just and accessible pathway for the average person to participate in court. And it has really limited the negative repercussions of these required personal appearances for all parties, such as missing work or not being paid for work or fear of getting fired or accessing childcare or fear of getting arrested if they show up at the courthouse, fear of deportation, the trauma of seeing the other party, etc. So, for e-service and these other electronic things that we've done, we've seen some real benefits.
Thank you so much, Shelley. That was a really excellent and comprehensive description of what's happening around e-service. And of course, Washington State is really ahead of the game, and you're even ahead of most in Washington State because you did do the initial pilot. And so just a couple of things I want to observe, just a couple of observations from what you said, and then I have a few more questions for folks. One is this idea of doing a pilot. And if you're trying to make these kinds of improvements in general around service of process, including using electronic means, but other things too, trying them out on a pilot basis for a fixed period of time and then kind of assessing how it worked, what the impact was, what the impact on your agency was, what the impact on survivors is, and what the impact overall in terms of outcomes is, can be a really effective way to make some change without having to, bite it all off in one piece. And so we've seen this again and again in this area where a pilot has kind of spread throughout jurisdictions or even states, and that's true of Lafourche as well. They were kind of the incubator of a lot of great stuff in Louisiana. Another piece is to be so attentive to what this means for survivors, and clearly you all in doing this work asked what the impact was in terms of their experience. And then also, of course, for respondents, we want to set respondents up for successful compliance with these orders. We don't necessarily want to arrest them. It'd be great if we didn't have to arrest them and prosecute them. It'd be great if they complied with orders, right? And so thinking how service of process can set folks up for success. And I'll ask actually questions about how you do that through your interactions in Lafourche County with respondents to try to get them to understand what's going on in this case, what their role, what their responsibilities, I should say, are, and make sure that they comply with orders. So back to you in Lafourche County. Can you tell us a little bit about how you got to this point and the obstacles that you overcame to get there? Shelley did a great job describing the obstacles they were facing, which led them to modernize their system. What about you all in the development of your program?
So let me start out just generally. I was first elected sheriff in 1992, so I'm in my 32nd year as sheriff and recently reelected. And in most of the decade of the 90s, if we had 5 or 6 homicides a year, that was about average. But we would always see half of them drug related and half of them domestic. And then occasionally there would be an unrelated homicide that was not a drug related homicide or domestic. And so we started out with a victim services unit. That victim services unit evolved into a police social services unit. And in the mix of all of that, we were very fortunate and very proactive in grant funding from Violence Against Women and other federal grants to become more proactive. We set up a lot of domestic violence training, a lot of domestic violence specialists, and we made this a big priority, recognizing that we were having people that were being murdered at an unacceptable rate for a preventable crime, particularly a preventable crime where the perpetrator is known to the offender in almost every case. And so we had specialists like Lieutenant Martinez and others, Captain Carla Beck, who is now in corrections, and they set about looking for solutions. And part of the solutions was enforcing, getting protective orders issued, getting them served, and getting them enforced. And not just getting them served and enforced, because I think a previous speaker pointed out as well, maybe not directly, it's providing information to the person who receives the protective order. We're not here to set up tripwires. and look for opportunities just to arrest people for something that practically on its face may not be, obvious to them. And so Valerie and her staff do a good job of interacting with the defendants and letting them know, look, we're here to get you through a process. And part of that process is your due process, because you'll have your right to go to court and to be heard on this. And we find that contrary to what probably many lay people think, many of the people are not looking to escape or run away. And I think the example used with the e-service it being so effective is that, yeah, people are accepting their service. You're removing some of the stigmas away. I'm very interested in that concept. I could see that Valerie and I are whispering to each other and figuring out if we can pioneer that. Louisiana's brand new governor, who was elected in October, will take office in January. He was our attorney general. His office was very proactive in the area of domestic violence and protective orders, and particularly gun prohibitions. So we're excited. We think some opportunities are going to exist there. We've partnered with them in doing a lot of statewide trainings, and his first assistant is now our attorney general. So we really have some continuity on a state level. But I'll go back to Valerie and let her fill in the gaps.
So what we do is we also recognize the importance of notifying the petitioner upon service, and that's part of the other questions. But is that communication with the defendants is to explain what they can and cannot do. Most agencies hand a paper, walk away and kind of read it yourself, fend for yourself. We advocate for sitting there, taking as much time as possible. I mean, of course, if the defendant allows, oftentimes they're kind of hesitant or resistant to the document, but we'll make it a point to explain. We will offer them our phone numbers for follow-up, for phone calls for us. And sometimes they may need an escort to get their personal effects, their clothing, their work equipment, all that stuff. And that we don't want to bog up patrol and having to take those escorts to do that. So in our office, we will communicate with the defendant. We will assist them and aid them in that transition of enforcing that order as much as possible. However, we have to be mindful that we do not want to interfere or disrupt the petitioner as much as possible. So we really firmly believe that the defendant plays an important role in the violation component. And if we could minimize that by aiding them and assisting them through the understanding of the order, stipulations, what it means to third party violate. So we kind of do a little education with them when we serve them. So it's not just dropping an order at their feet and walking away.
I want to use an anecdote. Way back when many of the states were passing sex offender registry laws, Louisiana had revamped their sex offender registry laws. So I brought in a group of very seasoned professional police officers who had been working on the job for quite some time, gave them copies of the new law and said, now tell me how you're going to comply. You're a sex offender. You have to notify everyone who lives within 1 mile of where you reside. How are you going to do that? And quite candidly, they had no answer. They didn't know whether they could walk from door to door and knock on people's door and stick stuff in their mailbox. And they didn't have answers to other questions. And it wasn't because they weren't trying to do the right thing. But the point was, if you as the police officer, the people charged with enforcement, don't know how to comply, then how can we hold someone accountable for something that we ourselves can't do? So that notification, explanation, understanding component for all parties, not just the offender, but the victim as well, because sometimes, victims make mistakes and they think protective orders can do things that they really can't, or they themselves misinterpret them. So it's really important for that learning curve.
Yeah, absolutely. Thank you for sharing that. That's a great analogy. And I really both you two and Shelley, are talking in part about a little bit about around procedural justice as well, right? Shelley talked about that. People understanding part of procedural justice is the understanding and the feeling like you're being treated neutrally and fairly through the process, and that can result in better compliance with orders too. So incorporating those concepts into service of process in these cases, these civil protection order cases, where, as you said at the very beginning, Sheriff, it's a known, you know exactly where the danger is at that point. The person, the target of the previous abuse and the potential target of future abuse. It's just so important to take all the steps we can to again, set them up for success. So along those lines, I don't know, Shelley, if there's anything else you can share around what's done by I know you're not an officer who serves orders, but I know you work with them, what they do to kind of set respondents up for success. And if you can, the next thing we were going to talk a little bit about is firearm surrender. And King County has a process for addressing firearms that is, again, was kind of at the forefront. Lafourche does some amazing things too, and as well as other communities, and some of them have built off what happens in King County. So would you be willing to share a little bit about what you know around what officers do in King County?
Sure. So Seattle PD is one of the ones who has been maybe doing it the longest. So they were the subject of the pilot. They have some best practices that they've come up with. They attempt to call the respondent first before sending the email. They attempt to then confirm the email address and advise that they will be sending the documents, give them information about what it says, and then they request that the person send a response. So those are kind of their best practices that we've seen. Our King County Sheriff here is also doing a really great job at that. They have an entire service unit. Most of our jurisdictions don't have that luxury. So they're having patrol officers or others, non-commissioned officers in the office, maybe in the records department, maybe doing some of the e-service. But King County Sheriff has a dedicated unit for civil service. And so we see a lot of success coming out of there. The officers try to request read receipts when they do get a response, when they fill out the proof of service. So it is required that they fill out that proof of service document saying which email address or text message or number or social media that they sent it to, the date and the time. And then what we're seeing is that they will attach the responses that they receive. So if they receive an email response, they will print it out and attach it to that, creating a really nice record for the court to be able to go back and see. I will say that we still have some confusion with some of the jurisdictions. Some of our jurisdictions seem to tend not to do as much e-service. And then there are some officers we are seeing who don't seem to be counting it as served unless they get a response. So some cases that we're not seeing a response, we know that they sent it. They're sending a screenshot of the email that they sent, but since they didn't get a response, they're counting it as non-service. Interestingly enough, that's not exactly what the statute says. And the court in some of those occasions has gone ahead and accepted that as good service, even though the officer didn't seem to think it was. So again, there's still a learning curve. We're still in the process. Things happen very differently depending on which one of our 39 jurisdictions is doing the e-service.
Right. Now, thank you, Shelley. And I know from having worked with folks in King County for many years on this, that there are some of the agencies, there's a sit down. It's similar to what Sheriff Weber and Lieutenant Martinez Jordan said about, knowing many of the petitioners kind of beforehand and getting a sense of what's happening in their case and some of the lethality that's being presented by the respondent in the case, that folks from the sheriff's office or from the prosecutor's office will sit down with the petitioners and talk about what's happening in their case, identify these risk factors and ask questions about firearms so that the officers have a packet of information when they go out to serve that's not served on the defendant, on the respondent. They get just the paperwork, but this extra paperwork about the case and the situation. So officers are kind of well-informed and able to do the job effectively and safely as well. And I think that's, I hear pieces of that in what you said in Lafourche County about knowing these cases, at least the ones where you've worked with them in court previously, your advocate has worked with them in court previously. That can be a really effective way to make sure that the service is safe. And it relates to the next thing I wanted to ask about, which is about notification of the petitioner. Often working nationally in this area, we see that in most instances, the victim is not notified when the paperwork is served. They don't get information about what happened at service. They don't get information even that it was served unless they go digging for it, ask the right person. There's no connection that's made that's easy for them to just get that information, whether it's through an advocate or others. So I wanted to ask folks from both jurisdictions, I'll start with you, Sheriff and Lieutenant, What steps do you take to ensure that victims are aware of, notified of what happened at service, whether it was affected, anything else that they would need to know about that process?
Well, what we do on our end, we recognize the need to, like you said, officer safety and pass along additional information. We have what's called a notice to the officers that does not get served on the defendant. It's a bright sheet of paper, has a bunch of information, notice like threats, any threats to officers, an eviction, removal of a laptop, a dog, whatever needs, any special conditions that are issued in the order. Even though we advocate for the officers to read them for their own safety, but we're able to put information is there a violent history between the individuals? And so on there, we could put any, excuse me, any additional information is notify the victim upon service. When we work directly with the individuals applying for orders in our office, they know they could call our office. And we will not only tell them of the service, but we will submit to them a copy of the proof of service, so they'll have it. We'll activate it in our system. But in addition, they also are aware that they can call our dispatch, our communications office 24/7. Our dispatchers can pull it up and verify the service. But most of the time, we'll specifically put a personal note that the petitioner would like to be personally contacted upon service. And that's normally our process. But a lot of times they will want them emailed as well. So we'll give them their email address and we'll email the return of service to the petitioner.
Thank you, Lieutenant. Yeah, simple step, but really important and effective and overlooked by many agencies. Shelley, anything to add from the King County perspective in terms of the victim survivor notification or involvement in this process?
Yeah, we hear from survivors and, in the protection order program, we work with survivors, obviously, from all the different jurisdictions. We hear from them that some jurisdictions are really great about calling them and letting them know. Some survivors come in and they have copies that were, emailed or mailed to them of the proof of service. So we do hear of some of those jurisdictions doing a great job. We know that a lot of the jurisdictions don't let folks know. What happens in our county is because of the protection order program. If folks are in contact with an advocate or find out about the advocacy program, they will often call us with questions about service. And we can pull up the court file and we can see in there if we have proof of service in the court file. So we don't know if maybe the respondent has been served and that proof of service just hasn't been filed yet. It's in transit somewhere. But we can look in the court file and see what the court sees if we have proof of service in the court file. So we will often encourage petitioners to go ahead and call us, and we can always look that up for them. And then some of our jurisdictions are really great also about documenting service attempts, while some are still struggling. Part of the new statute and the modernization was that officers are statutorily directed to document all of their service attempts and then to file those even if they don't manage to serve. And that's also because our statute, we do have those specific cases where they are wanting personal service still. However, if there have been multiple unsuccessful attempts at service, the statute does allow for the court then to grant authorization for e-service. And so in those cases where we're looking at removal of firearms or transfer of children or removing a respondent, if we haven't had any luck serving, if the officer submits their attempts and we have proof of 2 documented attempts at service, then the court in the next hearing can go ahead and grant authorization for e-service. And so it's really important that law enforcement does that, and many of them do a great job. And then some of them, we don't seem to see a lot of attempts that are documented. So again, it's kind of a mixed bag.
Thanks for sharing that, Shelley. And just as a reminder, in case you missed it, Stephanie Bowman chatted in a link to the revised statute around these service issues, the e-service issues that Shelley is talking about. I can tell you from having some conversations with folks while the process was going on and then after the process that this revamping or modernization of the civil protection, actually the overall protection order process in Washington State was a long and very collaborative effort. The folks who kind of spearheaded this spoke with all stakeholders that you want to talk to about how the system's working, what the improvements should be, what the language should be, and so a lot of the very thoughtful kind of step-by-step approach that Shelley just laid out is now part of the legislation, and it came from these conversations. And so this legislation, and then also we can connect to some of the people who are involved in it, can serve as a real educational resource for those of you who are thinking about doing this work. Not to say that you absolutely need a legislative change to engage in some of these practices we're talking about, including around electronic service. You may be able to do it under your existing statutes. So we're not saying that, but what we are saying is that it was a very thoughtful approach that has a lot of elements that we think are worth considering. If you are thinking about improving your system, and especially including e-service, but this statute modernization included a lot of other stuff. Shelley mentioned virtual hearings and things like that. There are other pieces too of the legislation that's really instructive. So thank you. Before I go on to my next question, just a couple of things quickly. You may have, some of you were probably coming on expecting to see someone from a third jurisdiction. We were going to have an officer from Pulaski County, a very rural part of Virginia. Unfortunately, right at the time we were starting, he got called onto a priority call. And so he hasn't been able to join us. He may try to join us before we're through, but he sends his regrets for not being able to join us all. The second piece is I wanted to open it up and make sure that if folks have questions, observations, things you want to share about your processes, the chat is open, and we would love to see any observations or questions that you have in the chat. We'll respond to it if you have questions. I just want to remind you, please, we want to make this as practical and useful for you all as possible. I'm just going to wait a minute, give us a little breather here, see if anyone wants to chat anything in, and then we'll move on. All right, I am not seeing anything in the chat.
I wanted to ask something. Do people get charged for issuing a PPO by the sheriff? Well, I live in Upper Michigan, and we're on a reservation, and we go through the county prosecutor to serve our PPOs if he decides they're worthy.
Right.
And then we get a charge by the sheriff.
Gotcha.
What do people do about that?
So thank you for asking that really important question. And it's actually, you may be surprised to learn that it's kind of a Michigan specific question that you're asking, and it doesn't really impact folks elsewhere. Let me explain very briefly why. All of our states and territories get money under federal programs, including the STOP grant program, which is a formula grant program where money comes from the federal government to the states to be distributed to subgrantees within the states. To be eligible for money under that grant program, the state territory has to certify that they're not charging for service of process of protection orders, like PPOs, and or other aspects of civil protection orders as well, not just for filing, for in criminal cases, witness subpoenas and things like that. No charges should be levied on the protected person. However, in Michigan, because your statute says that personal service is always an option and it doesn't have to go through law enforcement, it's been interpreted to say that law enforcement is able to charge fees because people can get it served for free by getting another adult to do the service of process. So you're in kind of a unique position. The STOP money can be used to pay for that service of process. And so the STOP administrator is potentially able to use STOP funding to pay for the service, and it wouldn't be the individual, but you're in kind of a unique position. Nowhere else are folks charged for service of process because it jeopardizes millions of dollars in state funding. And if you have follow-up questions around that, please reach out. I'm gonna chat in my email address, and I'd be happy to talk to you a little bit more about that as well. And actually, I just got a private chat saying that, which I didn't know, that State Domestic Violence Coalition in Michigan has money that's set aside to help with that situation. So definitely contact me and I'll get you connected with folks around that. Thank you. There was a question about guns, and that is exactly where we're going next, but I just want to make sure that there are no, I'm just typing in my email address here for you. Make sure there aren't any other questions.
I have a quick question.
Yes.
Do you find any trouble if there's a violation of the restraining order? I know pre-COVID, we had the issue, like if a defendant third-party contact through the internet, like sent a message through social media, that the defense would often say, how do we know it was that person behind the keyboard?
Right.
Do you ever find that as an issue?
Yeah, in the prosecution of violations.
Yes, I know it's
Yeah.
still a pretty new program. Just wondering
Right.
if that's ever come up.
Yeah, so I don't know, Shelley, if you can respond to that from the perspective of your experience in King County.
Yeah, we do see that, and I would say that is not so much an issue of service, because we have those cases where everyone is roundly in agreement that the respondent was served, the respondent was at the full hearing. This is after the full hearing when we have a full order. So there's no question of service, but that question of do we know it was them that sent, the social media message? That is really, I would say, depends more on the individual officers who are responding to those calls and kind of what their feeling is about that and how compelling they find the evidence or the story. And then the prosecutors, how much evidence do they think they have? Do they think they have enough to prove their case beyond a reasonable doubt? So I would say that we see that as an issue, not so much with service, but really, that's one of the things that we always talk to petitioners about. Once you do have a full order in place, it's really up to the responding officers to determine whether or not a violation has occurred. So it's really in people's best interest to be as specific in their orders as possible. So we always try to tell people, let's be as specific as we possibly can to kind of eliminate this, is it a violation or is it not a violation? So when a petitioner tells us, that they would like the respondent to be able to, let's say, communicate with the children by phone because they want them to have that contact. We always kind of talk it out and say, rather than saying they can call the children by phone, leaving it open to a respondent who calls 30 times a day or calls at 3 a.m. And then when they, officer talks to them, they say, well, I was just calling about the kids. We tell people, well, maybe you want to say that they can call Monday, Wednesday, Friday, one time between 5 and 6 p.m., right? Because then it's very clear to law enforcement. So I would say that that's probably not a service issue, more of a, and we know that respondents will often push the boundaries on any order. And so I think that's more of a kind of a
Yeah,
safety advocacy issue. Yeah.
that's what I was a little worried about, is if more like you saw the restraining order was opened in email or text, but then there's a violation and then they're stating, well, I never received it. I wasn't aware of it. How could I follow this if I wasn't aware, even though you have the read receipt or something like that? I was just wondering if that was an issue.
Mhm.
If you're seeing that.
Yeah, that would be in the case maybe of a violation of a temporary before the full hearing. But what we see is when the respondents show up at the full hearing, then there's no doubt whether or not they know the terms. And so after the full order is granted, we don't have to worry about those. Every so often we do, respondents who no show a full hearing can sometimes come back and say, we've seen some of them be successful in, if they say that they never received the e-service of being able to argue that a full order should be vacated and temporary reinstated and then have their day in court. We've seen that happen.
Thank you, Shelley, and thank you for that question. I'm gonna ask about one more question, then I want to make sure we talk about guns. And then there was a question about petitioning and e-filing, which if we have some time, we'll definitely address. For now, we'll talk about some service issues, but Adam, who asked that question, would love to be able to get back to you on, there's some resources and some conversations we can have around e-filing as well. The other thing I'm going to do before we get to the firearms piece and the other question is to put in a plug for the National Council and the Civil Protection Order guide that I talked about earlier. We have a couple of supplemental pieces coming out soon, and one of them addresses technology. And so issues around on the service side, but also on the violation side that was mentioned and things like that, some guidance around technology, how it's used by people who are causing harm, but also how it can be used as a tool within our systems to increase access to justice and safety. And so before we move in the guns, one more piece, which is around the language access question that was asked. Shelley, based on your experience in King County, you're the person here with the most experience, so we're leaning on you. What would you say around ensuring language access as part of e-service?
You know, I think language access is always an issue for all parties. I think it's always an issue for respondents, because even with personal service, if the officer doesn't speak their language, they are going to be personally serving them documents that are in English. And if they don't read English, even if they are personally served and they have these documents, they may not have any idea what they say. And so I don't know that it's necessarily an electronic service language access issue, because the person receives the documents the same way, they have them electronically, but they still may not be able to read them. I think they're kind of in the same boat as they are when they're served personally. At least if they have these electronic documents, they're able to potentially forward them on to someone who might be able to tell them what they are. I mean, I feel like language access is a huge issue, but I don't know that there's a difference between being electronically served and being personally served with documents that you can't read. I think that's a language access discussion, maybe.
Yeah, thank you, Shelley. And if anyone else has experience with this, I don't know if, yeah, Lieutenant Martinez Jordan, did you? Yeah.
I know it's not your traditional response, but oftentimes I have served individuals, even if like she said, the document itself is in English and they don't read English. I've actually aided and assisted them in downloading an app that you could open up a screen on there. Like she said earlier, everybody's got smartphones. So I help them download the app, and you can actually put the screen on the document and it'll translate it from whatever language for them, and they can read it themselves. So we've done that. It's not 100%, but it is shown to be very effective for them for the immediate, until like Ms. Shelley said, until they could get it to somebody else.
Yeah, someone requested the name of the app, if you don't mind sharing it. Not an official endorsement from all of us,
Correct.
something that Lieutenant Martinez Jordan has used it successfully. So thank you.
Correct. It's just
And
called,
oh.
I'm sorry, it's just called, I'll hold up a picture of what it looks like. It's just a translator. It's called a translator.
A translator.
And you can open it up to a document and it'll translate the document in front of you. Or
Thank
even
you,
your
Lieutenant.
Google Lens translate, and you put it on top and it'll translate it to any language you want.
All right, thank you. That's a big issue, obviously, this language, and it's broader than just e-service, of course. We appreciate that question, and we can have, maybe that's something we'll talk about in a future webinar. I noticed that someone mentioned that they would love to see a uniform order of protection across states, so it's easier to understand, recognize, especially for interjurisdictional domestic violence issues. And there's actually an effort, and there's some states whose first pages at least look similar, something called Project Passport. Dating myself, this was back in the early 2000s, where several states developed a kind of common first page. But this is certainly a challenging issue, because it's state by state, obviously, and these forms are developed by committees within each state, and that can be a real challenge. I want to make sure we have time to talk about guns, so let's talk about the firearms piece, and then we'll come back and see what other questions there are, because I know that both of you have stuff to say about firearms. And why don't we start with Lafourche Parish, if that is okay. I think I called it county before, I apologize. Lafourche Parish, and what you do around where there's an order to surrender firearms as part of the order that's being served?
So just by way of a little brief history, we were very much indebted to King County for their policies and their guidance in the whole area of divestiture and their laws and procedures as well. In fact, for many years, I'm still on the board of directors for the National Sheriff's Association, and a former colleague, Sue Rahr, was the sheriff of King County back then. So she was very instrumental. And while we had the process and we can mirror much of what they were doing, Louisiana had not yet enacted any legislation allowing for divestiture. So still being proactive, we began in not enforcing the federal law because we don't have the authority to enforce federal law, but making offenders aware of the federal law. They didn't know whether we could enforce it or not, but we sure made sure they knew that there was a law and they would be committing a federal crime by violating that law. And there were a handful of cases where we were partnered with ATF because they were good partners and we had a good relationship, and they actually came and enforced some 922 violations until the point in time when Louisiana finally enacted a law. And so we then created much more detailed procedures to comply with Louisiana's law, which very similar, but not exact to the federal law. I will say one of the best things that if you're from law enforcement or involved in the law enforcement side, one of the things that you have to recognize today is that the complexity of the legal system for the average police officer or deputy is overwhelming. You know, in 1980, when I became a police officer, there was more common sense. You could almost enforce the 10 commandments and you pretty much got the law right. But today, there's so many subparts and changes and what else. So with our records management system, what Lieutenant Martinez and her staff do is every time there is an order of protection that qualifies for divestiture, or there's a conviction that triggers divestiture, they go into the system and they identify the offender and they put flags on that offender's name. And the purpose of those flags is to take all the guesswork out of the deputy's decision-making process. When a deputy interacts with a person, whether it's as simple as a traffic stop for running a red light, or it may be a call for assistance, a medical emergency, who knows what, that deputy automatically looks in that system and it will tell him if they're prohibited, and it'll have a copy of the paperwork and it'll have all the information they need. And if at that point they're still confused, then they call out an expert or they call one of Lieutenant Martinez's staff people. So that's kind of how we got to where we are. The law was initially passed and we jumped in head first and we were excited. And then there were many jurisdictions, and this was very disheartening to me and very frustrating, how many law enforcement professionals created all sorts of false excuses, I won't say false, excuses as to why they could not do divestiture. Well, it's dangerous. Well, who, if not the police, is supposed to deal with dangerous things? I mean, like in school violence, right? Don't we go after the offender and shoot him, or we're not supposed to do that? I mean, that's silly. Liability. We don't have enough room in our evidence room. I mean, just some silly arguments. And I'm thinking, did you ever sometime in your career, like take an oath where you protected life and property and defended rights and constitution? So I still get frustrated and probably get in too many debates with people who just run away from their responsibility, as I would like to say. But Valerie, you can talk about in nuts and bolts and the mechanics of what you do.
Okay, and so the question proposed is, so what do you do with an order of protection that has a firearm prohibition? Well, now we have legislation that mandates, now let's say twofold, if the defendant is present in court, they have to disclose in open court where they have firearms, where they are, and then they're gonna be sent to our office and immediately the firearms are then removed. We have to, by law, aid in either a transfer to a third party, a sales, and or a licensed dealer to hold the firearms. For us as an agency, our main objective is to cause a physical separation of that prohibited possessor and that firearm immediately. So we chose as a sheriff, and you could, if you just listen to him speak, you know exactly why we absolutely love him as our sheriff, because he's a true champion for he advocates for victims of domestic survivors and removing of firearms from prohibited possessors. And he chose to say, you know what, I'm not going to charge a fee. because my objective is to cause that physical separation. I don't want it to be him angry because it was a $15. I'm not gonna do that. So we don't charge a fee to take in those firearms. But we do often advocate for a third-party transfer, and that is done by legislation, within 48 hours, it has to be done. But most of them are sent to us immediately upon the issuance of the order, and they come to, now, I mean, the order to transfer, not the protective order. But at that time of the hearing, they have to transfer within 48 hours. But during the temporary order, they are not prohibited. It is not until after that due process and after that show cause hearing. So immediately upon the order being granted and extended for that period of time, it causes that prohibition. However, we do have state law, but we still are waiting for the Supreme Court decision for USS versus Rami. And so that was a decision for the Fifth Circuit. And we're just waiting to see what happens there, because they determined that to be unconstitutional at a federal level. So we're waiting. But until we hear otherwise, it's kind of business as usual. And if they are prohibitive and they have guns, that is absolutely something that we will be removing from them as expeditiously as possible.
And Valerie, why don't you talk about the mechanical process of how you have them show up with a gun in the trunk or?
So our process is, and it's drafted into policy, is they meet us at a specific location. It's prearranged. The firearms are unloaded in the farthest part of their vehicle in the trunk, locked. The defendants have to get out. They meet with us. They stay with the secondary officer. I take the key. They cannot come with the secondary person unless they can't drive. We walk across. We take the firearms while they're watching, but from a safe distance, they're watching. We're logging. We're putting everything that documenting the identifying markers of the firearms, and then we give them a copy and a receipt of those firearms that are taken. And if they chose that third party, we are aiding in that process of transferring those same firearms to that third person. So that is how that is done on our end. But after that order is issued, we take the matters of firearms very serious. So it's, like I said, it's in our policy. If you would like our policy, we'll be more than happy to share it with you. But they come to that secure location. And then what we also are making sure that we do is the orders to divest, upon their ability to repossess the firearms, the process is just as quick, because we do not want to interfere with their rights to possess. So we are mindful that upon that no longer that prohibition, the existing that prohibition, we aid in returning those firearms.
And can I thank you to both of you? Just a couple of quick pieces. On the return of the firearms, I assume there's some kind of background check done to make sure there aren't any other prohibitors in place. Is that correct?
Absolutely. There's actually a motion. They have to file a motion with the court. The court has to sign off. Then that motion to review comes to our agency. I have a return of firearm process that we complete. Then it goes through the DA if there's a criminal charge, and then it gets submitted and filed back with the court, and the judge reviews it. We don't tell the judge what to do. We just offer the information of any convictions, any outstanding fees, because the law allows that if there was a transfer and a fee outstanding, they cannot reobtain those firearms till all those fees are satisfied. And then, so yeah, there's a checks and balances with the return as well.
Thank you. And one other piece I want to just briefly mention, thank you for bringing up the US v. Rahimi case. Supreme Court is currently considering whether to reverse the Fifth Circuit, which makes it the law in Louisiana and Texas and Mississippi, that, or at least they found 18 USC 922 G8, which is a part of the Federal Gun Control Act that prohibits people who are subject to certain kinds of protection orders, meeting certain requirements, from having firearms, that was unconstitutional. We'll see what happens at the Supreme Court level. Meantime, as you said, business as usual. You're operating under, sorry, my phone is ringing. You're operating under state prohibitions that are still in place and still not affected by Rahimi. We all are. The final piece I want to mention was just a third party, the transfer to a third party. And is there any kind of regulation of what's happening with a third party? Does a third party undergo a background check? Is there any way to make sure that that person is allowed to have guns, and also, or that they cannot, that they understand that they're not to allow access, constructive possession, access to those firearms by the person who is prohibited?
Yes. Absolutely. The third party person goes through a rigorous background check. They cannot be a household member of that prohibited party. In addition to that third party, they have to sign what's called a third party transfer acknowledgement form, where there's a specific law that was drafted that if they provide those firearms to that prohibited person for any cause, for any reason, that there's a specific charge, they will be arrested and charged for providing firearms to a prohibited possessor. So there's an agreement and an understanding that they know they cannot do that, and the penalties if they choose to still violate and return those firearms.
Thank you, Lieutenant. Absolutely. And I noticed there was a question, a request for the policy that you have in place. I have a copy of one. I don't know if it's the current one. So if you don't mind sharing, I know people are interested. And I also have copies of King County's protocols around service and firearms too, that we'd be very happy to share with participants on the call. Shelley, anything to add from the King County perspective around guns and domestic violence?
I can
And
talk.
protection orders and service, since we're kind of focusing on service and protection orders. Yes.
Yeah, I could talk a little about guns. Originally it was supposed to be the supervisor of our firearms unit who is here today, and she could have obviously given you a lot more detail. So about, I want to say 6 or 7 years ago, perhaps, King County created the Regional Domestic Violence Firearms Task Force. It's a team of folks whose sole purpose is really to get firearms out of the hands of people who are abusive. So here in Washington State, once the court at a full hearing hears both sides and makes a determination and makes a finding of domestic violence, if the parties are current or former intimate partners, it is now statutorily required that they enter an order of surrender at that time that they enter the full order. If the relationship is other than intimate partner, the court can also make that determination if they make a finding that the person poses a credible threat to the safety of the petitioner for some reason. However, if they are current or former intimate partners, that is actually not even an option for the court. They must enter that order to surrender. So when people are filing their temporary order, it's kind of a given that they will, if their order is granted, that there will be an order to surrender weapons. And so the way that's working now is that if a full order is granted, the respondent is told at the hearing that they are also entering an order to surrender weapons. They are told that they will need to show proof of compliance to that order. That order gives them 5 days to surrender their firearms. And then they are also scheduled for a follow-up compliance hearing in a completely separate courtroom on a docket that does nothing but compliance hearings. And that is where the court is going to look at the evidence and see if they're in compliance. Our firearms team does a ton of work. They do background checks on folks. They look at purchase histories. They scour people's social media. And we will get folks that say, I don't have any guns, and they will come up with all these pictures of them on Facebook holding all of their weapons and present them to the court. So the court is going to get the information from the firearms unit and hear from the respondent and check and see if they're in compliance. Our firearms team, since they started, has had remarkable success in getting firearms away. Back after when the unit was new, I remember there was an article that the local newspaper presented of a gentleman who swore under penalty of perjury at his hearing that he did not have any firearms. The petitioner insisted that he did. The firearms team actually ended up being able to collaborate with law enforcement, get a warrant. They removed 17 firearms from that individual. And so they have quite a few success stories like that. But here in Washington, we know that for some petitioners, they are really concerned about the respondent's access to firearms in the meantime before the full hearing, because the full hearing is always set 14 days out. And so some people say, you know, if the respondent gets served with this full order, he's going to go ballistic, he has a gun, he's probably going to come for me. So in these cases where petitioners are really afraid of weapons, we also have the opportunity to petition for what's called an order to surrender weapons without notice. And so that is heard at the same time as the temporary protection order. And if the court feels like there is a compelling reason to enter an order to surrender without notice to the respondent before due process, they can enter that order temporarily. And that matter will be heard together at the full hearing and make the determination. So in those cases, as soon as the respondent is served, the order tells them that they have 5 days to comply. And the firearms team really jumps on those orders to surrender without notice. They do all of their due diligence. They have partnerships with a lot of our law enforcement agencies. They will also reach out to the petitioner and talk to them. If the person asks for an order to surrender weapons without notice, our court in Superior Court in King County also requests that they fill out an additional firearms attachment, giving more information. So what kind of guns, how many guns, where's the last place you saw the guns, where are the guns kept? They aren't able to file that order to surrender without notice without that firearms attachment. And then the firearms team will follow up with them to get all of that information to try to strategize how law enforcement can safely remove those weapons. So that's how we're doing it here. Our statute says for electronic service that personal service is still required when there's an order to surrender without notice, because the idea with the legislation was that we didn't want to e-serve a respondent so they get this email that says you have to surrender your weapons and then give them time to go hide those weapons or give those weapons to a friend or family member where they would have access to them. So the idea is that they would be personally served with both orders in the moment, and that law enforcement would say, here's an order to surrender weapons, you need to surrender them to me now. That is the idea.
Thank you, Shelley. And
We
I
do
know
know that, yeah, I was gonna say, not all of our jurisdictions are taking those weapons in the moment. Some of them do consider it a safety hazard, and so they are following up to schedule a similar situation, what I heard in Louisiana, to schedule a time where the respondent could bring them in. But that's how we're doing it here.
Thank you, Shelley. And I know from working with folks in the sheriff's office that that there's a whole approach to service when there's a firearm. I mentioned earlier these kind of service packets where they have information about what guns, where they are, any dangerousness factors that are presented, the criminal history. And they take what they sometimes call a warm approach, which is kind of a knock and talk approach where they come in and it's not a very confrontational setting. They'll come in plain clothes, sometimes unmarked car, to do the service of process and try to keep the temperature down, and have reported, and research has shown now, because there's been a study of the impact of the regional group that Shelley talked about, that have found a lot of success in getting people to give up their guns, recognizing they'll have a chance to have their say in court, and could get the guns back if the court doesn't issue the final order. So a really good set of practices for people to be thinking about. And I know, as Sheriff Weber said, they borrowed some of that in developing their work. So we have about 10 minutes left. There was a question that I want to try to get back to, and then I'm just going to ask our panelists to talk about any lessons that they've learned that they would want to share with any of you out there who are struggling with your current service of process system. But let's start with this question, which is, I'm going to just read it out here if you didn't see it in the chat. Our county does not have e-service. There are occasions when an emergency order, and an emergency order, I'm assuming, means one that's issued by law enforcement, not by the court. An emergency order was issued, the individual has been removed from the scene, from the home. But when the petitioner gets a temporary protection order, PFA is a form of protection order, they don't have an updated address. So they can't get that temporary PFA now, which needs to be served on the respondent. Any tips or tricks for locating those individuals under those circumstances? And I think these are kind of general tips around people who are hard to find, who may be transient, maybe moving around, especially after an incident. I don't know if Sheriff Weber and Lieutenant Martinez Jordan, if you have any thoughts around tracking folks down in cases like this.
Yeah, we would use our standard investigative procedures to, I mentioned, we have a very robust records management system. it will track any and all addresses associated with that person through link analysis. So we might go in there and find 5 or 6 different locations. Of course, family members and associates are also tracked, so they're a very rich source. And social media, digital evidence. If we have a phone number that that's related to that person, we can probably get a warrant. We can start tracking it and identifying physical locations. So we will use all of the regular investigative resources that we do to try to locate and apprehend any other person that is trying to avoid identification and apprehension.
Now, if you're an NGO advocate, you're an advocate organization, you can also use a program. Look, I'm not advertising, but there's something that we use and it is amazing. It's Accurate. And you could actually buy a prescription for law enforcement or a non-law enforcement entity, where you could find family members that go back 10, 4, 5, 6 generate of like
Neighbors.
yeah, exactly. And you could you'd be surprised what you could get, but we use Accurate a lot out of our office.
Yeah, it's one of several commercial. I think LexisNexis has a version of that as well, of people locator programs.
So just that old school law enforcement, just investigation.
Yep. Great, thank you. All right, well, let's wrap up with our final question, which is for folks who are struggling with some of these issues, any words of wisdom beyond what you've already talked about, anything to motivate folks or maybe to help get collaborations going to try to address these issues like you all have achieved in your communities? And I'll start with you, Shelley, if that's okay.
Wow. Well, like you mentioned, the big overhaul in July of 2022, to our statute that came about, I believe the work that was being done to do that was like 2 years in the making. We had a group of advocates and, civil legal attorneys and our state gender and justice commission, all working on this. They found some allies in legislature who were really interested in this, to help kind of move that work along. But again, it was a long process. Like you mentioned, Darren, they spoke to stakeholders, they did focus groups, they asked for advocate feedback. There was quite a bit of thoughtfulness that went into this. Our statute hadn't been overhauled in 30 years. And so they didn't figure we're going to be doing it again anytime soon. So they really wanted to cover all the bases. But I think it was all a matter of relationship building and coalition building and kind of folks coming together and like I said, finding some allies in the legislature who this issue was important to, kind of bringing it to them. Yeah.
And you had your community had already laid a lot of groundwork around collaboration, had historical, so you're able to, draw on those connections. Absolutely. Sheriff Weber and Lieutenant Martinez Jordan, any words of wisdom or motivation or advice for folks?
I have a couple of thoughts I'd like to share. So if you're struggling, then that's probably an indication that there's either a lack of understanding by people in decision-making positions, chiefs or upper level ranking officers, people in the legislature, NGOs, so on and so forth, or people have misguided priorities. And what worked for us is we didn't have those issues here because we were all united. But for many other jurisdictions, they are not united and they're not prioritized. Louisiana didn't get a law until there were advocates, 5 advocates from various organizations, Goodwill, other NGOs, mostly domestic violence related. And they brought the matter to the forefront and they started rallying support. And we got into the legislature before the Criminal Justice Committee. The bill was brought up and I was there to testify as well as other people. And within minutes, this bill just sailed through this legislature. Everybody wanted to co-author it and then it got passed and got put into law. And then it took a while for the implementation, but at least we had a bill to stand on. Look for those advocates, look for those people who are politically involved and let them sometimes carry the torch. Because if you're a civil servant employee, there's only so much that you can do in the political arena. But if you're not, election time for mayors or legislators or sheriffs or police chiefs or governors is always a good time to confront people with statistics, to confront them with the number of people that die as a result of an offender having a gun and the danger to families. And the fact that this is an insidious crime and it's cyclical in nature, because if you are a witness, a child who witnesses this type of behavior or a victim of it, then you're more likely to precipitate it in the next cycle and the next generations that follow. And as I mentioned previously, it's a crime where the perpetrator is known and accessible. It's not a crime where you don't know who to pick or where to start looking. I think too, with any advocacy, you really need to try to work with, if you have gun advocate groups, whether it's NRA or other gun advocate groups, to make sure that they're understanding and have an appreciation that you're not trampling over the Second Amendment. And they had, in our case, we didn't have any opposition from NRA when this bill was brought forward. So I think those are important, and inevitably, you either have had or will have that tragedy where that victim reported multiple times, had applied for protective orders, tried to do everything right, and they end up on the front page of the paper or the back page of the obituary. And then the law gets named after that person. And you hate to capitalize on a tragedy, but sometimes that might be what it takes to get to the point of getting people to take the time to understand that it's achievable. It's not some mystical thing that can't be done. And there's proof of concept in places like King County, Lafourche Parish, and many other jurisdictions that have advanced.
Thank you, Sheriff. Anything to add, Lieutenant?
And that is exactly why I wanted to have him here, because I could sit here and tell you all day what we need to do, how we could approach it, how we could do it. But if you do not have that buy-in from the top, from those organizations, it's not going to work. It has to be a philosophy. It has to be a mission. It has to be a passion and drive. And that is exactly what we have here with our agency, with this wonderful sheriff sitting next to me. And that is exactly why I wanted him to come share these words.
Thank you, Lieutenant, and thank you, Sheriff, and thank you so much, Shelley. So we'll say goodbye. Before we do that, there was a question about electronic filing. Please reach out. Please reach out. We can talk to you. We have resources. I know there's some people online here who are listening from organizations that have a focus on that issue. We can point you in the direction of ways to do e-filing in a way that's going to be very victim survivor centered. As opposed to what works for the system, what works for the users, and that we would love to share. So I'll type in my email address one more time. Actually, I should give you a different email address. You can reach me at either of them. And I want to say thank you so much for sharing your passion, your energy, your commitment, and your achievements. To all three of our panelists, you're really doing amazing and inspiring work. You inspire us all the time. I have to say that for those of you who work with me and my colleagues at the National Council, they hear about Lafourche and they hear about King County all the time because of the remarkable work that you're doing. So really appreciate it. We appreciate you taking the time today, and appreciate everyone who's come to listen to us for an hour and a half on this issue. There is a recording. It will be available soon. We'll send out resources to everyone who registered, and have a great rest of the day. I'm going to finish typing in my email address here. Have a great rest of the day, and thank you again. Take care.
Thank you.
Thank you so much, Darren.
Thank you. Bye, everyone.